We are accepting the report of the Registrar Judicial. We hold that there may not be any ground for initiating a criminal proceeding, but there is a suppression of material fact by submitting deficient certified copy of the FIR, and therefore this case may be a case where the anticipatory bail may be cancelled, may have to be cancelled, but as the petitioner has not prayed for cancellation of anticipatory bail, therefore a week's time is given to the petitioner, to you, Mr. Khan, your clients, to file an additional affidavit as to why the anticipatory bail granted earlier should not be cancelled. In addition to that, certain directions are given for the registry on administrative side to ensure that such things does not happen in future. So next date is fixed on 6th of January. Before 6th of January, you may file. And public prosecutor is also requested to take instructions from the investigating officer whether custodial detention of the petitioner would be necessary.
Yes, yes,
The orders mention about that.
yes,
You can go through the order.
yes.
You may also have a copy of order.
Yes.
6th of January.
Yes, thank you.
For reasons mentioned in the orders, the petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to certain conditions.
Obliged.
Latif. Latif, I will request Latif. Kindly take up item number 5.
Item
My-
number,
Yes, my junior is coming. I will be placing after that.
okay. Yes, Mr. Ahmed.
Yeah, please, your worship. Worship, here the petitioner was arrested on 20/12/2022.
22.
20/12/2022.
How many days of
Today,
detain-
Lordship, he has completed 2 years.
What are your grounds?
Lordship, basically, Lordship, I am paying bail on 2 grounds. The first ground is Lordship parity. There are 3 persons arrested. 3 persons were arrested on the same day. They were forwarded by the same forwarding report. Lordship was pleased to grant bail to one of the arrested accused person.
Where is that order?
That order, Lordship, is at page number 93.
93.
91, my lord.
Okay,
Basically-
on what ground he was allowed to go on bail?
Prolonged incarceration.
Okay. So you are also praying for
Same.
prolonged incarceration?
Yes, Lordship.
What is
As-
the,
As of now, Lordship, no witnesses have been examined.
no, when the charge sheet was laid?
Charge sheet was submitted on 30/04/2023,
And
30th of April 2023. Charges were framed on 30th of July 2024.
yes, Mr. Thakur.
My lord, yes, this item number 5 and 6, my lord, of the same scan copy, my lord, same case, my lord.
Item 6, my lord, also. The
Mhm.
last occasion day before yesterday,
Yes.
matter was heard. And my lord, on the other day, I have filed a compilation. On that day, the Kuwait Zamiruddin bail was granted by a judge.
Same case.
Same case, my lord.
Same
And
case,
my
Lord.
lord, I have submitted some citations on that day. There is a compilation, my lord. And I want to add one more, my lord, citations. In this regard, in this case, my lord, the Honorable Supreme Court granted bail in 1 year, 5 months. Due to prolonged in
No, I will not
No,
bring it down to 1 year, 5 months.
Yes.
What is the reasoning?
Reason here, my lord, 2 years is completed. Till now, no PWC examined.
Reason is that you have right to get speedy trial.
Yes,
if you are
right
detained.
to get speedy trial. And
Okay,
My lord, yes, my lord, there is no doubt that the accused person right to speedy trial is one of the concurrent Article 21. My lord, for that, my lord, getting speedy trial, so my lord, the prosecution will, at the same time, my lord, there is, my lord, due procedure of law has to be followed, my lord. And my lord, there are, while the, my lord, petitioner has cited, my lord, there is decision of the Honorable Supreme Court, Shariful Islam, and other decision, and all those decision, my lord, source of all those, my lord, decision based on initially, my lord, from Hussainara Khatun, thereafter Muhammad Muslim, and all these decisions, my lord. And from my lord Hussainara Khatun, my lord, yes, my lord, yeah, it is specifically that, my lord, just a pre-trial detention must be based on reasonable, just and fair procedure. And thereafter, my lord, in Muhammad Muslim, your lordship, I'd like to point out, my lord, while the accused my lord, Satinder Kumar Uncle's decision, my lord, before that Muhammad Muslim. My lord, here specifically, my lord, Satinder Kumar Uncle has discussed about 436A of the CRPC.
but Satinder Kumar Antil also speaks about,
Speaks about the procedure, and while my lord speaks about that, also mention about 436A of the Criminal Procedure Code. And while my lord, Muhammad Muslim case, my lord, in that case, my lord, the detention of the petitioner is, my lord, 7 years. My lord, already, my lord, he has completed, my lord, half of the sentence, my lord, and thereafter, my lord, only on other, my lord, peculiar facts and circumstances, and because trial not yet started, and my lord, he has already completed, my lord, half of the sentence of the punishment. So on that ground, my lord, petitioner was allowed to go on bail, my lord. However, my lord, I'd just like to point out in Muhammad Muslim's case, my lord, one paragraph 12, your lordship may kindly peruse, my lord, I'll point out one portion, my lord. While, my lord,
well,
while discussing about the Article 21 of the Constitution, my lord, and speedy trial, learned, my lord, Supreme Court has also observed, my lord, paragraph 12, my lord, I have pointed out, my lord, in sermon, of course, my lord. Paragraph 12, my lord, last portion, of course, some amount of deprivation of personal liberty cannot be avoided in such cases. But if the period of deprivation pending trials becomes unduly long, the fairness assured by Article 21 would receive a jolt. It is because of this that we have felt that after the accused person have suffered imprisonment, which is half of the maximum punishment, my lord, provided for any offense, any further deprivation of personal liberty would be violative of the fundamental right visualized by Article 21, which has to be telescoped with the right granted by Article 14, which also promises just fairness, reasonableness in procedural matters. So, my lord, there is no doubt about
no, this observation was made in a different case,
Yes,
which is quoted in Hussaina,
yes,
Shariful. Quoted in Muhammad Muslim.
yes, my lord. Otherwise, my
The-
lord, in Muhammad
What
Muslim,
you have to assist this court is every case will be dealt with according to facts and circumstances
my
of each
yes,
case.
my lord.
Every criminal case is
Yes, my
different.
lord. Otherwise,
the
my lord,
principle laid
in
down-
this case, Shariful Islam,
No,
my lord.
listen to me. Then you will be able to help me.
Yes,
The query is that every case, in some cases, detention may be 4 years, 3 years, 2 years. The principle laid down by Supreme Court is that what I understand is that if there is prolonged incarceration,
there is no doubt.
then it will override the embargo of Section 37.
Yes, my lord.
Now, whether it is prolonged incarceration or not, it depends upon the facts of a case.
Yes, my lord.
And in most of the cases which I have dealt, this court has held that period of 1 year, 6 months in the given circumstances of that particular case can be regarded as prolonged incarceration.
Yes.
That is finding as to facts.
Yes.
And principle is, if there is prolonged incarceration, then you are entitled to get bail
Yes.
due to violation of Article 20, your rights
Yes,
under
yes,
Article
ma'am.
21. Now, in this case, you have to submit that this 2 years detention is not prolonged incarceration.
Yes, ma'am.
Because otherwise, I don't think you have any other scope.
Yes.
Because if this court holds that they are detained prolonged, their detention is long
Mm.
and trial is not progressing as desired, then they will get bail.
Yes,
Then
my lord.
embargo.
Otherwise, my lord, while my lord, your lordship has rightly pointed out everything, my lord. Yes, there is, of course, my lord, while in case of prolonged incarceration, violation of Article 21, there is no doubt about that. And my lord, in recent decision, Supreme Court has also discussed about speedy trial, fair trial and everything, my lord. And now, my lord, in some cases, my lord, societal impact of these, all these, my lord, drug traffickers and everything has to be also, my lord, discussed in some of the judgments, my lord. And regarding the context of the present case, my lord, in some cases, it was also discussed about, my lord, the persons who are responsible for causing the delay. It is on the part of the accused or in, on the,
Yes, is
in
there
some
any
cases, my
fault
lord.
on their part?
my lord, maybe, my lord, whoever in fault, but ultimately Article
No,
20
but suppose if accused is at
yes,
fault,
my lord, here in this,
then they may not get benefit.
yes, my lord. Here in this case, my lord, what happened?
In
One
this case,
accused,
not even a single witness has been examined.
yes, examined, my lord. In this case, my lord, one Sarifuddin, my lord. He is a, my lord, one is accused person was absconder, my lord. And because
Whether
of
he is before this court.
he is not before this honorable court, my lord, and because of this, my lord, thereafter, my lord, after splitting the case on 4/6/24, my lord, charge frame on 37/24.
But why the petitioner should suffer for the fault of Sarifuddin?
Because, my lord, in some cases, my lord, your lordship may accept my argument or not, my lord. Now, my lord, what happened? This type of some tactics used by the, my lord, accused on the, in some, your lordship may find
No,
later
no.
on also.
Have detained them for 2 years
Yes, my lord.
and trial have not yet started. What tactics they are using? They are only behind the bars waiting for their trial.
And my lord, here only because, my lord, one is absconder Sarifuddin. He is also one of the co-accused, my lord, along with other accused person. And my lord, till now, my lord, that Sarifuddin not yet arrested, my lord. And now, my lord, search frame on 37. So there is every possibility that, my lord, in a short period regarding the present accused persons, my lord, trial will be completed.
When the charges were framed,
Search frame on 37/24. My lord, my humble prayer, my lord, on these all these grounds, my lord, although, my lord, it is up to your lordship. My prayer before your lordship, my lord, although, my lord, your lordship cannot fix any time frame in view of the Supreme Court guidelines, my lord, it would be difficult for your lordship. But your lordship can direct that, my lord, within a, my lord, short period of my specific period, the entire trial needs to be completed, my lord.
what was the
After-
contraband?
Contraband, my lord, 739.01 grams of heroin, my lord. And, my lord, some societal impact is also there because, my lord, if all these person, my lord, it happens, my lord, sometimes they will again, after release from the jail custody, they will again involve in
No,
committing this type
therefore
of
these
offenses, my lord.
offenses are to be tried expeditiously.
Yes, my lord.
Okay, tomorrow morning, delivery. Heard Mr.
Item 6, my lord.
Item 5 of M. Ahmed, learned counsel for the petitioner, also Mr. P. Bhattakur, learned additional public prosecutor. Let this case be fixed for delivery of orders on 20 December 2024. Similarly, item 6, so AK order.
Item 6, HR Chandra. HR Chandra.
I would like to want one recent reason regarding, my lord, society, discipline, your lordship, like-
No, you tick mark the para which you are relying on.
Yes,
Lordship, may I place the judgments, Lordship, which I'm relying?
You are relying on the same judgments.
My lord,
Lordship, I'm relying on the judgments, Lordship, which Lordship has already referred to in the judgment of Zamiruddin. All things have been discussed there.
Then you
Is
did.
granted the- I
And
have
Lordship,
already-
another point is that the only added point is that, Lordship, the grounds of tariff is also there, Lordship.
No, you are basing your submission on the main ground on which the
Yes.
other accused.
Yes, Lordship.
So parity is not necessary.
Yes, Lordship. Then lordship, the judgments lordship, which were discussed already by your lordship in that case lordship, I'm relying on all those judgments lordship. Therefore lordship, I'm not supplying the copies lordship.
My lord, I have submitted citations and relying on the other judgment. Recently, one judgment was passed by the Honorable Supreme Court in respect of Assam's case, madam.
What
Let
is
me
the
get-
name?
This is Dhirendra Kumar Chaudhary versus the state of Assam. This is a very recent judgment passed by the Honorable Supreme Court. It was right to speedy trial, the bail was granted.
Next one. Okay.
Highly organized.
On my behalf, your lordship may allow me.
Yes.
Lordship. Lordship, this is an application under section 482 of the BNSS for pre-arrest bail in connection with Samaguri PS case number 29/24 under section 341, 325, 326, 294 and 34 of IPC. Lordship, the informant and the petitioner are own brothers, and they have some landed disputes for which this case arose. And Lordship, the real fact is that
No,
the petitioner had also.
let us first go to the FIR.
Yes, Lordship.
What are the allegations?
And the fifth person is in absconder, no?
Lordship.
Search sheet submitted,
Charge sheet has been laid.
submitted, no?
Yes, Lordship. FIR
Charge
at page 11.
Charge sheet has been submitted.
Yes, such it has been submitted.
Then you will receive summons from the court.
Yes, Lordship.
Then why are you appealing?
Then the petitioners had applied for PRS bail. That was rejected. And thereafter, the petitioner, in order to approach the legal forum, had filed an application for adjournment.
The offenses are tribal by sessions court, no, magistrate.
No,
court.
magistrate court.
Then where is the
320.
apprehension?
Lordship. As because the anticipated
Now charge sheet has been laid.
it had been laid.
You are shown as an absconder.
Yes,
The trial court would issue first summons to you.
yes, Lord.
Then you can appear and pray for bail. Then
Lordship.
court will grant you bail.
No, Lordship, the one adjournment, one petition was made on medical ground on 30/10/2024. Lordship, at page 28, the
Yes.
court has rejected the prayer and issued NBWA, for which the petitioner has come to this court.
No, issued NBWA.
Yes, Lordship. The page 28, order dated 30/10/24. Only on the ground that earlier anticipated bail was rejected, only for that reason, without showing any other reason, the court has rejected and
No,
issued
but suppose if it has issued NBWA, still the trial court has jurisdiction to grant you bail.
of course, Lordship.
It-
But there is
Then
no
where
any-
is the apprehension that you may be arrested?
And here, my lord,
Lordship,
NBWA has not been challenged.
Let him come.
Yes.
Lordship, as because the order it was issued NBWA, so certainly the court will reject my prayer in the
No,
event of
no,
my
no.
appearance, or if it is arrested, if I am arrested on the strength of NBWA, police will not release me on bail.
That may be a ground.
That Lordship.
When
that
is the next date fixed?
next date is fixed on 4/1/25. Lordship.
Then you pray before the trial court, bail. We will stay the NBWA. Police may not arrest you, but you have to pray before trial court. Trial court will consider your prayer. If it feels that your
Lordship, because the charge sheet was filed in the month of April, Lordship, and there is a cross case between the parties.
No, I am not on that.
Okay.
You have to satisfy me only one thing. That whether trial court is empowered to grant you bail or not. It is empowered. Police is not empowered to.
Yes, Lordship.
Therefore, you need protection from police till 4/1/25. Because in between, if police arrests you, it will not allow you to go on bail.
Yes, sir.
but trial court has power to grant you bail.
Lordship, this court has ample jurisdiction and power to grant bail because of the fact that.
No, but if trial court is having that power,
Yes.
then why to exercise that? Moreover, this court has to be satisfied that your apprehension is genuine apprehension. You are only that apprehension that on
And deal with.
on pro- your production before the trial court after executing the NBWA, you may not be granted bail. This is a speculation only that because trial court is empowered to grant you. We will make some observation.
Yes, Lord.
Yeah, otherwise, only difficulty is that order, my lord, issuing NBW has not been annexed here.
Yes, sir.
No,
An extra 4.
that is an e-court.
Yes, understand. It's postponed.
You appear before trial court.
Yes, sir.
Trial court will not arrest, send you to jail. Unlikely. Or you satisfy me that why trial court will send you to jail
Lordship,
legally.
yes. Lordship, the
Yes, Mr. Upadhyay, you have any?
Otherwise, my lord, if you want to face the trial and my lord,
He is ready to face
he is
the
ready to face the trial, my lord, then let him appear at trial.
heard Mr. Darakulla, learned counsel for the petitioner. Also heard Mr. P. Bhatakul, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the, how many petitioners are there?
2 petitions.
Has been filed by the petitioners, namely Masrab Ali and Ahmad Ali, who are apprehending their arrest in connection with PRC case number 220/2024 in connection with Samaguri PS case number corresponding to Samaguri PS case number 29/2024 under section 341/325/294/34 of the Indian Penal Code. The gist of accusation in this case is that on basis of an FIR lodged by, who lodged the FIR? Lodged by one Iman Ali on 30/1/2024. Wherein it was alleged that the accused persons named in the FIR, within bracket, 5 numbers of accused persons were named in the FIR, bracket close, had trespassed into the land of the first informant, and when the informant and his son tried to stop them, they assaulted them, causing injuries on their person. Stop. After injuries of their person. Stop. After registration, on the basis of the FIR, on the basis of the aforesaid FIR, Samaguri PS case number 29/2024 was registered and investigation was initiated. Stop. After completion of the investigation, charge sheet was laid in the said case, showing the present petitioners as absconder in the charge sheet. Stop. It is submitted by learned counsel for the petitioner that the petitioners and informant are brothers in relation, and there was a land dispute between them. What else is your submission?
Cross case of the petitioner has also filed court case.
and a dispute broke out between them. And an altercation occurred between them due to the land dispute. And in that regard, the petitioner's side has also filed a cross case against the family members of the first informant of this case,
Samaguri PS 30.
which is registered as
Samaguri PS case number 30
Samaguri
oblique
PS case number 30
30
oblique
oblique 24
2024.
under section 447 325.
So, learned counsel for the petitioner has submitted that the petitioners are ready and willing to face trial. And in that respect, they approached before the learned trial court by engaging a counsel and filed an adjournment petition. Filed an adjournment petition before the said court. However, said adjournment petition was rejected as an earlier pre-arrest bail application filed by them before the Sessions Court, additional Sessions Court was rejected. The trial court, while rejecting the adjournment petition filed by them, had also issued non-bailable warrant of arrest against the present petitioners. Learned counsel for the petitioners has submitted that as the petitioners are ready and willing to face trial, their custodial detention is not at all justified. However, they apprehend that on the strength of the non-bailable warrant of arrest issued by the trial court, they may be arrested at any point of time. Hence, he has prayed for issuance of favorable order under section 482 of BNSS. BNSS, 2023. On the other hand, when an additional public prosecutor has, yes, Mr. Bhattakur,
Yes, my lord.
anything?
Otherwise, my lord, considering that they are absconding, my lord, since long, my lord, on that ground, I have objection, but regarding that,
Has, though has objected on the ground that the petitioners are shown as absconder in the charge sheet. However, considering the submissions made by learned counsel for the petitioner that they are willing and ready to face trial, he fairly submits that their custodial detention may not be necessary for fair completion of the trial in PRC case number 220/2024. Considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, this court is of considered opinion that if the petitioners are ready and willing to face trial, their custodial detention may not be justified. And as the petitioners had appeared before the trial court by engaging their counsel on 30/10/2024, the trial court could have fixed another date for their appearance instead of issuing non-bailable warrant of arrest on that day. In view of above, it is directed that the petitioners shall appear before the trial court on the next date of appearance, that is before the trial court on the next date of appearance, that is 4/1/2024. Stop. And cooperate in the trial. If they do so, and if they do so in accordance with this order, on their appearance before the trial court, they shall be allowed to go on bail by the trial court of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the trial court. Stop. The operation of non-bailable warrant of arrest issued against them shall also remain suspended till 4/1/2025. With above observation, this bail application, anticipatory bail application is disposed of.
To look.
One more matter is there.
Madam, this matter may be come up after Bihu vacation, madam.
On request of learned counsel for the petitioner, let this matter be listed after the vacation.
I can go on, see.
7.
May it please your worship.
No supplementary list of, Yes,
May it please your worship. Lordship, this is an anticipated bail application, lordship. Here, FIR lordship will find on page.
okay, this is, you have any, here I have to write a judgment.
Offences are, my lord, Riya Chakraborty's case also, my lord, in this regard, my lord.
What say, what Riya
I
Chakraborty
would
case?
like to point out, my lord, at last. One paragraph 45, last portion, my lord. After this,
Please read out.
considering all this discussion, I am of the firm view that the observations made by the Honorable Supreme Court in Baldev Singh Supra are binding and all offences under NDPS Act are non-bailable. my lord.
What has been observed in Baldev Singh's case?
Not in that Baldev Singh's case, my lord, also with all these offences are, my lord, as non-bailable. my
Okay,
lord.
give it
Well,
to me, give that judge,
Yes, your lordship.
Riya Chakraborty.
Yes.
Your submission is that a coordinate bench of this court has already held
That it is
that
available.
it is
lordship.
bailable.
And moreover, lordship, section 37 said lordship offense to be a cognizable and non-bailable. When the body of the offense lordship, a body of the definition.
Now, in this application, one question is there,
Yes,
that if it is bailable,
yes, lordship.
then anticipatory bail is
Yes.
not maintainable.
Yes, lordship.
Then it has to be dismissed.
Lordship, then there, it is not maintainable, but there may be direction to approach before the court below for obtaining regular bail, lordship. In this case, lordship, what
No,
happened?
regular bail, if you are not arrested, the question of bail does not
But
arise.
it's a bailable that was not specified in the code lordship. Because in that case, lordship, this offense lordship.
Charge sheet has been
My lord,
laid.
No, lordship.
My lord, his contention is that while in the heading, my lord, it is specifically mentioned that my lord is non-bailable. And because the contents of that, my lord, after that contents are not my lord stated clearly that this is my lord non-bailable. During discussion, Supreme Court has discussed, my lord, from the my lord earlier till my lord from all these amendments were also discussed and contents of section 37
Okay, I'll go through.
not at all same. and, my lord,
Suppose I hold that it
Yes.
is non-bailable,
Yes, yes.
then it has to be
Then-
referred to a larger bench.
Yes, lordship. Yes.
And if
lordship.
I hold that it is bailable,
Yes, lordship.
then order
Then-
has to be passed.
Yes, lordship.
Then this bail application is not maintainable.
Yes, lordship, that thing. Lordship, one thing, lordship will appreciate. This NDPS Act has been amended time to time, lordship. Legislature has not made any move to lordship codify it as an bailable or non-bailable lordship. That was not their lordship. Even that lordship, Supreme Court said lordship, if that has been dealt for a particular case lordship. In the code lordship itself said lordship, when the, if lordship peruse the 37 lordship is specific lordship, the offense to be cognizable and non-bailable. But the first para of subclause 1 and A, it specifically says every offense punishable under this shall be cognizable. Why not they have stated lordship, it is non-bailable?
Okay. No, here the
Oh,
matter is
All the
different.
everything has been discussed, my lord.
We have to I have to disagree with Riya Chakraborty's opinion
yes.
if you want a favorable order.
Yes, Lordship. Riya Chakraborty's case, Lordship, that is Bombay High Court
Then
case.
I will have to go through it.
Yes.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Upadhyay, P. Borthakur, learned additional public prosecutor. Hearing concluded. Let this case be listed for delivery of orders on 3rd of January, 3rd January.
Obligation. Lordship, I have placed one Karnataka High Court judgment, Lordship, for perusal purpose, Lordship.